time as a barrister, his commitment to multiculturalism and pro bono work saw him attract national acknowledgement in the area of human rights and immigration law. And in 2012, he was an Australian of the Year Tasmanian finalist. There is much I could say here, but I'll just finish by saying that Justice Estcourt was appointed as a member of the Order of Australia in 2018 for significant service to the judiciary as a judge. So highly esteemed, and many of you may also remember reminiscences of a food tragedy, because Stephen has, and still is, I think, a strong commenter on food. He does cooking demonstrations, quite the chef, and a bit of a food blogger. So maybe we could have a few questions about that. But in his spare time, he of course has written a book, and this will be the primary discussion today about the history of the Supreme Court here in Tasmania. So please welcome Stephen to the microphone.
Thank you. Have I got sound? Yes, I have. No question about knowing 2/3 of you. In fact, I think we all went to school together, didn't we? I remember you all from grade 3. Kathy acknowledged country, referring to U3A. I just finished reading Martin Flanagan and Auntie Patsy Cameron's book, U3A. And of course we've got to realise that there's another name for Tasmania too, because a lot of the northeastern Aboriginal Tasmanians don't use Palawakani, which is the language that's promoted by the Tasmanian Aboriginal Corporation. So, U3A. Food demonstrations, yes. Well, I don't think we'll talk about food demonstrations today, but the last time I had a microphone on was at the Coonya Garlic Festival, doing a demonstration on how to cook rabbit sausages from scratch with garlic scapes. Yeah, I'm here to talk about the Supreme Court for sure, and the book that came out last May to celebrate the centenary of the Supreme Court. But first it might be useful just to put the Supreme Court into a political and a geographical context before we talk about the history. Because from a political point of view, the Supreme Court is the third arm of government. It is not a government department, and I'm sure everybody understands that the doctrine of the separation of powers requires that there must be complete separation between the legislature, the executive government and the judiciary. Now that's the Westminster system that we inherited, and my Supreme Court very much cherishes its independence and is alive all the time to ensure that independence. The reason for that, I think, is pretty obvious, that you've only got to look around the world or on the TV at the moment to see that institutions are very fragile, and we must never think that the independence of our judiciary in this state or this country can be guaranteed without continual vigilance on the part of those who form that arm of government. The Supreme Court of Tasmania is the highest court in Tasmania. Now it's subject only to the High Court of Australia. The nomenclature there is a bit interesting because, as you know, there's the US Supreme Court, which is the highest court in the United States of America, and now the English House of Lords, which used to be the highest court in the United Kingdom, is the Supreme Court. And New Zealand has its Supreme Court, all the highest courts in their respective countries. But our Supreme Court is here in Hobart, another one in Melbourne, another one in Sydney, but our High Court is in Canberra. Although it does travel a bit. The only South Australian ever to be invited to join the High Court refused because he said it would be like the fifth wheel on a cart. travelling around Australia dispensing unwanted justice. So we are the highest court in Tasmania. Not to be confused, our home is down at Salamanca Place. A number of you, I know Kathy for example, have done open day tours when the Institute of Architects have their open days in October. So we're physically located in Salamanca Place. Not to be confused with the Magistrates Court, which is down opposite the Royal Hobart Hospital in Liverpool Street. The distinction between the two courts is very fundamental in many respects, but at a superficial level, the Magistrates Court deals with less serious offences, and magistrates have only jurisdiction to sentence someone to imprisonment for up to 2 years. Our judges of the Supreme Court have unlimited jurisdiction in law and in equity, and sentencing power up to life without parole. So the more serious cases come up through the Magistrates Court to the Supreme Court. The Supreme Court deals with other things as well. That's where all probate goes. If, like me, you've given a moment's thought to the next 20, 30, 40 years, you've probably prepared a will, well, that's where your will go, and that's where probate will be issued in our Supreme Court. It's where all civil cases go: damages claims, work injuries, motor vehicle accidents, contract claims, bankruptcies, all of those sorts of things, although to a lesser extent bankruptcies these days. And it's where all serious criminal cases are heard before a jury of 12. I know Kathy won't mind me saying she was on one of my juries last year, I think, and I knew I recognised her face when I came in this morning. That was it. So that's our jurisdiction. In a geographical context, before we start talking about the history of the court, I'll perhaps tell you historically where it's been and where it is now. I just said Salamanca Place. It started out on the corner opposite St David's Cathedral. Does everyone know where the Treasury building is? Okay, we've heard a lot about it in recent times, and its proposed sale. The original Supreme Court, built in 1824, or not quite finished in 1824, is on the top side. That is the St David's Cathedral side of the Treasury building, right next door on the corner. It's still there, it still has its original facade, although there are 4 columns now in front of the building, and there were only 2 to begin with, and other changes have been made to the facade. It now is occupied by Treasury. The original court's still there, the original space is still there. And opposite it, in 1824, when the court first commenced, was the prison. Now, it's a bit harder to describe where the prison was, but if you go St David's Cathedral, Victoria Tavern, which I'm sure everyone would know, Law Society building, Butler, McIntyre and Butler, the oldest solicitors, right in between Butler, McIntyre and Butler and the Law Society, directly opposite the court, was the jail. And the jail extended almost the full block. It had a wall. If you walk down that street now, you'll still see there's a drop and a picket fence, and that was the base of the prison. So there was a wall right up, and the gallows were directly opposite what is now the Treasury building. In fact, what is now the Treasury building had a good viewing site of the hangings, and officials used to gather there for morning teas and watch the executions opposite. Now, the court was dingy and dark. The prison was overflowing, almost from the word go. It was thought that there was a tunnel from the jail to the courthouse. When I was president of the Law Society back in 1988, I commissioned an engineering study to try and find this tunnel. Well, it occupied us for years. There were people who swore that there was a tunnel, that older people had been in it. Well, we found all sorts of interesting things in the base of the Treasury building, but no trace of a tunnel. It certainly makes sense that there would have been a tunnel, because dragging prisoners across the street full of horses and carriage, and mud might have been a bit interesting and a bit of a security risk. Anyway, what happened was that the prison had a large fire, almost burned down, and it was overcrowded anyway. So in about 1859, the Trinity Chapel in Campbell Street, has anyone been to the old Trinity Church building? It's got the clock, sorry? Yeah, the clock in that chapel was made by the same clockmaker as Big Ben. So in about 1859, 1860, the court, and we've got to remember we only started with one judge, the Chief Justice, John Lewis Pedder. Chief Justice Pedder had his little room in the court building. So what happened was the court went over to Campbell Street and took all of the criminal cases with it, and there was a penitentiary at the same place, and you may have even toured the penitentiary. It's very interesting. So the Chief Justice, and by now an extra judge, Justice I'll come to it in a moment, moved their offices next door adjacent to Franklin Square. So can you imagine where that stone building is with the big wide steps that go up to it, right next to Franklin Square, housed Algernon Sidney Montague was the second judge, housed the two judges, and the criminal cases went to Campbell Street, the civil cases stayed in Franklin Square. So the court was separated from 1860. So from 1824 to 1860 it was in that one spot opposite St David's Cathedral. The judges then stayed next door in Franklin Square, but the criminal cases went up to Campbell Street. So they had to travel to Campbell Street every day for civil cases. I'm sorry, for criminal cases. The court wasn't reunited for 120 years. It took until the buildings were built in Salamanca, in Salamanca, our present buildings, that the judges rejoined. The civil and and criminal jurisdictions came back together in the one building. So it was a long time between drinks, 1860 to 1979 basically. And at that stage, Mervyn Everett was the Attorney General, and he got wind of a plan to build a court in the present situation at the back of the front of St David's Park, and it was a monstrosity. It was a big square box that was meant to house all agencies to do with the law, police, prosecution, legal aid, all of those things. So Mervyn Everett, who was a very powerful man in his own way, convened a meeting and commissioned a government architect called Peter Partridge to build the new Supreme Court. And Peter was fresh from England, liked brutalism in architecture, and liked to build enduring buildings that would last, that couldn't be fiddled with by people in later years. So he came up with the idea of letting the park flow through the court. So if you stand in Salamanca Place now and look at the court, you'll see the criminal buildings on one side, the civil buildings and judges' chambers on the other, and a big set of steps running right up and opening into the court. He is an amazing man. He received a National Award for Enduring Architecture for the court, belatedly I must say. But he had the entire brief to build those buildings, from drawing the plans to choosing the timbers and the materials, the slates and the sandstone, all sourced by him, right down to the furniture and the carpets. The carpet in the Supreme Court now is the same as it was in 1976 when the criminal side opened, Tasmanian carpet, and it's as good as the day it was new. So yes, he had that job, but he also had the job of completely filling the building with everything that was necessary, right down to the cups, saucers, plates, tea towels, and the ashtrays in the toilets. Which I must say are still there, unused. And the toilet rolls that used to have the one sheet at a time click. Until Justice Peter Evans, who's my contemporary, he was there when I started, came in one weekend with his angle grinder and cut them all off. And even down to the orange laminacs in the jury rooms where the sink and cups and saucers are. So it was complete with 70s style and flair. Just quickly, in Launceston, the Supreme Court had 3 sites, one in Cameron Street, one in where the matric college is, the Launceston College is now, and one where it is at the moment, back in Cameron Street. In Cameron Street. Burney had 3 homes. It was in the police station to start with. It was a terrible old building where everything that witnesses were saying could be heard by the other witnesses out on the veranda having a smoke. And then it was ditched for a glorious building in Alexander Street of red brick called the Supreme and Magisterial Courts. Not magistrates' courts, magisterial courts. And of course it was built with the maximum amount of asbestos allowed. So when the government went recently to give it a big makeover and bring it into the modern day, they found out very quickly that they had to get away from there. And there's been a site chosen in the centre of the city now, but no soil's been turned at the moment. They wanted to send us out to the old university building up there, where you might have noticed on last night's news it's being turned into a medical hub. But the idea of having to get people to court otherwise than in the CBD is just ridiculous. It's bad enough as it is in Tasmania, where people have got to negotiate public transport from the northern suburbs to get into the city. So that wasn't for us, and we're getting a new court up there. The court used to travel to Strahan and Zeehan, hold circuits in Strahan and Zeehan, but it hasn't done for many years. So that's the geographical context. In terms of the historical context, our court is the oldest court in Australia, despite Sydney's great angst and continual insistence that they were first. The fact is, on settlement there was a military court, and then there was a court which was called a Supreme Court, which was run by military officers, with juries of military officers. There was no trial by jury brought into Australia with first settlement, even though the Charters of Justice would suggest otherwise, and I'll come to that perhaps in a minute, or that's probably a bit boring. But yes, there was a Supreme Court there, but the Supreme Courts in both New South Wales and Tasmania were established by the Charters of Justice, one for Tasmania, one for New South Wales. Our Charter of Justice, the original one, is in the State Library archives. It can be seen on request, and it's a most magnificent document. It was brought out by John Pedder, the first Chief Justice, on a boat called the Hibernia, and it's what is in what is called a leather banjo box. So the banjo box is like a cylinder, and it's got a big half purse on the bottom of it, all in beautiful leather. The seal sits in the long bit. The charter sits in the long cylindrical bit, and this huge wax seal sits in the bottom of the banjo box. It's a sight to be seen. So what happened was, in 1823, the British government decided to set up courts in New South Wales and Tasmania. The Charters of Justice authorising the establishment of a court with one judge, a Chief Justice, and a registrar was specified in that Charter of Justice. John Lews, L-E-W-S, Lews Pedder, was given the job of Chief Justice of Tasmania, and Chief Justice Forbes was the New South Wales first Chief Justice. Now, they both set out from, probably wouldn't have been London, where would it have been? Southampton. Set out from Southampton at the same time in separate boats. Pedder was in the Hibernia and Forbes was in a boat called the Guildford. And they both arrived in Australia, respectively New South Wales, Sydney and Hobart, at about the same time, at early March 1824. But what happened was Pedder got off the boat breathless just about and ran to Government House where the charter was read, and then the first registrar of the court, a man named Sorrell, which is a long family name in legal circles in Tasmania, he was the first registrar. He organised the reading of the charter in the marketplace, which was all that was necessary for the court to sit for the first time. Now, New South Wales can argue all they like. The historical fact is that on the 10th of May 1924, Sir John Lews Pedder convened the first court, the first proper Supreme Court in Australia. It is what's called a court of oyer, O-Y-E-R, and terminer, T-E-R-M-I-N-E-R, and general jail delivery, which means judges today can still walk into the jail unmolested, unrestricted, and require people to attend at the court. So that's what general jail delivery means. And until that kind of court, oyer and terminer and general jail delivery, was established in Australia, there was no proper Supreme Court that reflected the system of justice that was administered in the United Kingdom. So can I just, without boring you, just read two paragraphs from the book, which gives you a little bit of historical context. I say, Sir John Lews Pedder arrived in Hobart Town with his wife Maria aboard the barque Hibernia on 15 March 1824. A flag known as Signal 42 was raised at Mount Nelson, signifying that an important person was arriving. Lieutenant Governor Sorrell thought that the person was his replacement, Lieutenant Governor Arthur, who did arrive later on the Adrian. That was not the case. Pedder disembarked at noon on the following day, I'm not quite right, and proceeded to Government House, where he was introduced to Sorrell and other officials of the settlement. In his possession, Pedder had a document authorising the establishment of a Supreme Court in Van Diemen's Land. Now, this is interesting. It is a sobering prospect that when Chief Justice Pedder took his seat as the first Chief Justice of the Supreme Court several weeks later on 10 May 1824, 1. Transportation, which was to continue for another 29 years, had swelled the convict population of the settlement from 600 to 6,000 over the previous 8 years, and would continue to a peak of 28,500 in 1848. The first guests of His Majesty King George IV would not be housed at Port Arthur in any form for another 6 years. So when we think Port Arthur's old, the court started 6 years before Port Arthur was any sort of thought in the governor's mind. The model prison there would not be built for another 25 years after that. So the court had been in operation for 31 years by the time the model prison was built at Port Arthur. Lieutenant Governor Arthur's shameful foolishness, the black line as it was coined by contemporary journalist Henry Melville, lay some 6 years into the future. So the court dealt with, badly I must say, a number of cases involving Aboriginal Tasmanians in that time. More convicted criminals were being executed by public hanging than at any other time before or after in Australian history. So Pedder was, generally speaking, dubbed the hanging judge. I've managed to find a cartoon in the book which shows him looming over the entrance to the jail with a finger beckoning people in. And the motto of Chief Justice Pedder was flog and hang. So, I must say a fairer perspective has emerged with a book by Jacqueline Fox called By Every Tie of Duty, and she paints Pedder simply as a man of his time. And representative government, at the time the court first sat, would not arrive for another 32 years on 1 January 1856. So Pedder had a lot to put up with. He complained that he needed more assistance, and he appointed what was called the Master of the Supreme Court, now known as the Associate Judge. It was a man called Joseph Hone. Joseph Hone, it was said, was a man whose court was regularly attended for people to laugh at his hilarious manner. I don't know how they got on, but at least Pedder had someone else to share his scrutiny of many, many hides of parchment written closely, which is his complaint when he decided he needed someone else to help him. In my book, I certainly detail the way judges followed. The original Charter of Justice, as I said, specified only one judge, the Chief Justice, and it wasn't until later that a second judge was appointed, and then a third, and then a fourth and a fifth. We got to 7, and then the government went back to 6, and we only got back to 7 again a couple of years ago, in circumstances the court would rather not recall. We are now 7 again with the appointment of Justice Kate Cuthbertson. I'm rambling a bit, but Justice Cuthbertson, I might as well tell you, is now the 3rd female judge on the court. She is the 4th in total since the commencement of the court, which is nothing to be proud of. But the first woman was not admitted to the bar, not admitted as a lawyer, until 1935. Despite the fact that legislation was passed 30 years before that to allow women to be appointed to the bar, to become solicitors and barristers. The original designation was barrister, solicitor, proctor and attorney, simply known as Australian lawyers nowadays. But the first woman was a woman called Nancy McPhee. And of course, as you would expect of the time, she was no ordinary woman. She was the daughter of the Premier Sir John McPhee, and she'd attended Cleves House for her education. Can anyone tell me what Cleves House is now? Collegiate. Is it not? Well, you know, as soon as I said that, I realised, of course. But all of the reports, yeah. Clemes. Oh, it's good to have a bit of excitement, isn't it? Let's just have a look at McPhee. Nancy Helen, 309. Daughter of a former Premier of Tasmania, Sir John McPhee. educated at the time, Ms McPhee was educated at Leslie House in Hobart, which was at the time known as Cleaves, Cleaves College. Afterwards became the Collegiate College. So that's a relief. It wasn't for 30 years, it was 30 years rather, before the first woman was appointed. 3 men were appointed on the 10th of May 1824. Yesterday I admitted the 5,651st lawyer to the role. So in 200 years there have been over 5,500. I'm delighted to say half at least of those are now women. So the growth of the profession has been at a faster pace in terms of gender equality than the profession has. The opening of the Burnie Court, just before I get off Nancy McPhee, her appointment at the time was described in social fashion of the day in the Woman's Weekly. Not quite as bad as the opening of the Burnie Supreme Court, where our Governor, Kate Warren, is pictured in a miniskirt. Kate Warner, rather, is pictured in a miniskirt. I'll leave this book up here when I go. At the opening of the library, and the dresses were described by the reporter in the most amazing way. Nobody escaped descriptions of their dresses and hats. But in any event, to be fair, the report of Nancy McPhee's admission in the Australian Women's Weekly was in a section called What Women Are Doing. So it was a progressive slot in the Women's Weekly. Now, what else can we talk about that's interesting? I said that we didn't have trial by jury when the courts were first established. And as we had more free settlers come out, there was an increasing call for trial by jury, which was the right of every Englishman. We had juries of 7 military officers for a very long time, and there was a huge clash between New South Wales and Tasmania, because Chief Justice Forbes had interpreted a piece of legislation setting up what were called, it was a middle court, and middle courts were allowed to have juries, but the Supreme Court wasn't. So Forbes wrote an opinion saying that this particular piece of legislation clearly entitled everyone to trial by jury. After Pedder wrote a contrary opinion, and Pedder resisted trial by jury for many years after that. So the battle for trial by jury was very interesting. What was also interesting was the battle for a Launceston judge. That was thought to be an outrageous request by the citizens of Launceston, who were well served by judges from Hobart on circuit in horse and cart. Anyway, a judge called Ewing, E-W-I-N-G, had a wife who suffered from asthma, and her doctor had told her that she should go and live in Launceston because it was a much better place for asthmatics. Ewing went to the Attorney General behind the back of the Chief Justice of the day, and offered his services in Launceston, and the government accepted. And the first thing the Chief Justice knew about it was a report in the Launceston newspaper. So there was a hell of a to-do. The Chief Justice wrote to the Mercury saying that the protocol was that Chief Justices spoke to Attorneys General, not any other member of the court, not any other puisne judge, as we're all called, but P-U-I-S-N-E. But Ewing won out, was greatly lauded for his services in Launceston. After he died, he wasn't replaced for many, many years, and the government really never got over it. And it wasn't until a man called Sir Kenneth Green from Launceston was appointed to the Supreme Court down here and maintained his residence in Launceston, came down for his work and went home again, and inevitably started to do a bit of work in Launceston, that Launceston could say it had anything like a resident judge. After Sir Kenneth Green, it wasn't until Sir George Crawford was appointed as a Launceston judge. And again, after he died, the government were very slow to appoint another Launceston judge. It wasn't until quite a few years later his son, Ewan Crawford, who was a former Chief Justice of our court, said he would accept appointment to the court, but so long as he lived and worked in Launceston. And that was that. Now, I don't know, we've got over ourselves so far that now we have a Burnie judge, Justice Tamara Jago. I mean, the thought of having a judge resident in Burnie doing all of Burnie's work was appalling to those in the day. If you were going to Launceston, where Sir George used to come down here for his sittings, and he'd go home on the Tasman Limited with a Gladstone bag with 3 bottles of beer. So it was good enough for Sir George to take the train. You couldn't possibly have somebody being a resident judge in Burnie and worse still living in Smithton. So Tam does a magnificent job in Burnie, and it's well understood now that going forward there will be no judges going on circuit to Launceston and Burnie, except for the relief of the judges up there if they are taking leave or whatever. And we will have judges in Hobart, 1 or 2 judges in Launceston and a third judge in Burnie. All right, what else can I tell you? Baxter. There was a judge who never was, and his name was Alexander Macduff Baxter. And after Pedder had been sitting on his own for a long time, petitioned the UK government to appoint a second judge, they appointed him. He was an English barrister, had enjoyed no great success, but when he came out here to take up his appointment, Arthur found him to be, Governor Arthur found him to be in such a high state of what was the word he used? He described him as an insolvent debtor, notorious sot, and wife beater. He found him to be in such a high state of neurotic excitement and such an habitual sot that it would have been a violation of public decency to have him take his seat on the bench. So the government caved in and passed legislation authorising the appointment of a local judge if a judge appointed in the UK was not expected to arrive in a reasonable time to take his seat. There was no her about it in those days. So Macduff arrived to take up his position, and Arthur ended up giving him £50 to go away. Now, Sir Francis Villeneuve Smith was another one of our Chief Justices who was a remarkable character. His mother was a Mauritian. He certainly had a darker skin than was acceptable in Tasmania at that time. He became the most amazing politician, was vilified on the floor of the House continually. Every time he stood up, he'd be greeted with the N-word that is no longer acceptable. But he was resilient. He had a farming property out at Campania. He was probably one of the best Chief Justices of the day that we had, a very strong character, as you might expect. He fought a duel. So, yes, he's certainly a very interesting character. The second judge appointed, Montague, Algernon Sidney Montague, was the only judge to ever have been removed by Parliament. So he's the second judge of the court. He was removed because he got into an argument about a debt, and the debtor sued him in his court, and he ruled that he couldn't be sued in his own court. The creditor sued. He ruled that he couldn't. Creditor appealed to two judges, the only two judges there were, Pedder and Montague, and lost. So this enraged Arthur, who decided to get rid of him. But in reality, the reason for getting rid of him was political. It was very good to have a sort of a corruption allegation to bring against him, but the Governor Arthur was very upset about what was known as the dog tax, because in those days all legislation passed in Tasmania had to be looked at by a judge who would certify that it was in accordance with law and the law that had been received into this country from the United Kingdom on settlement. And Montague decided that this tax was unlawful. Now, as it related to dogs, it was neither here nor there, although the farmers were up in arms about having their dogs taxed. When Montague held it to be unlawful, it had huge ramifications, because the basis upon which he said it was not lawful in the Australian colonies was such that it applied to all taxes on everything. So it created huge difficulty for the government, and Arthur wanted him gone. He wanted Pedder gone too, as a result of that, but Pedder stood his ground. At one stage locking himself into his house when Arthur had sent sheriffs to arrest him. Look, I could go on. Is there any area in particular of the court? The book is ordered into the courts under respective Chief Justices. There have only been 14 Chief Justices, I think, or 15, I can't remember now, and about 48 judges in the history of the court. So the book's ordered into Chief Justices, and we've had some wonderful Chief Justices: Sir John Morris, Sir Guy Green, Sir Stanley Burbury, all standout Chief Justices of this court. But is there anything specific about the court or its judges that I could answer, or as to any of the aspects of the law that we administer?
We'll go with a couple of questions.
Yeah, by all means.
I believe the dog tax was to raise £374.05.
That's it.
English pounds. To build 3 hospitals.
Yep.
They were built of wood, and they were items that John the Archer, the architect, was commissioned to do. I suspect they weren't too good because none of them exist to this day. The other thing with the original Supreme Court was it originally designed by a stonemason who worked on it, and then followed up by David Lamb, who also built the part of the Richmond jail and also the bond school at TMAC, where I work as a guide. And
he arriving in Tasmania after the construction of the Supreme Court had commenced. Yeah. He took it. He took it.
Archer, hadn't arrived when David Lamb had finished building the Supreme Court, but
no, that's good.
Reminding people. Yeah. So the dog tax must have gone through, did it?
It did. It did, but it was.
Did it raise that sort of money?
No, it was struck down. So I don't know what happened to the hospitals. No.
You've named some outstanding judges. In your opinion, what are the characteristics between a good ordinary judge and one who's outstanding?
Well, I guess there are different sorts of judges. There are different sorts of doctors. We all know these days. Some have got a better bedside manner than another. My plastic surgeon who fixed my elbow up for me comes out into his rooms with a bowl of chocolates and passes them around. There are others who won't give you two words. So we need to have a balanced court of brilliant minds, but people with humanity and compassion. You know, mercy is no stranger to the law, and we can't be the subject of black letter law without reservation, without carve-outs. So I've been delighted in the 12 years I've been on the bench to find some people who write outstanding judgments and people who have amazing intuition and empathy for people who come before it. So, I mean, the best judge would be a combination of those two. Yes?
My question is to do with when we went from being colonies to becoming a federation.
Yep.
What impact did that have on the judicial system of Australia?
Well, of course, Andrew Inglis Clark was one of the designers of federation. Was your question what impact did it have on this court? Supreme Courts all over Australia. Yeah. Well, I guess people just had to get used to there being another layer of appeal. The High Court came here, I think, for the first time in 1903 and sat in the courthouse next to Franklin Square that I was talking about. But the minute there was federal law, there was going to be conflicts between state government and federal government over things like local taxes, for example, stamp duty, rather, all of those sorts of things, and taxes on trade between the states. Section 109 of the Constitution was there from the very beginning because we had two systems of law. It wasn't until a good deal after the High Court started that citizens started litigating their claims and appealing their claims to the High Court. To begin with, it was really governments sniping each other which occupied the court the most of all. But no, I don't perceive in any of the judgments pre and post 1900 that would say that the law developed in a different way after Federation. But the High Court certainly has the last word now, and we're just used to going to the High Court. When I first started as a lawyer in Launceston, your appeal to the High Court was as of right. Now you've got to get leave from the High Court to be able to take your appeal to the court, and the court makes a judgment on what's called a special leave application as to whether it's worthy of being taken on. The Supreme Court in the United States is even more discriminatory and takes on very few cases and decides them badly.
Thank you. You were talking about outstanding judges
Yeah.
and balanced decisions. My question is actually around juries, and you were talking about women coming to the courts not until the 30s. When were women eligible to become part of the jury?
Yep. Keep going.
I'm just sort of wondering
Look,
what would have changed to allow that to happen.
it was a gradual process. It came about as a result of women lobbying, and it wasn't until very late, shockingly late, I think you'll find. If I can find it quickly, I will. Otherwise, you can come and have a look at the index and the book after we've finished. No, I can't, but my sense is that it was in the 60s. But there was a transition period where women were allowed but not required to serve. And then after that, women came under the same obligation as men, that they were required to serve if selected, if selected from the jury roll, unless they were excused by the judge for some reason. But it's in the book. In fact, I must say, women played an amazing role in the development of the law in Tasmania, particularly in the development of criminal law. Women became enraged at the treatment of women and girls by the legal system, and played a very leading role in formulating the terms of the criminal code. There was a group of women known as the Furies of Hobart, and they were very, very active in bringing about reforms to stop injustices to women and girls. And children. Sorry.
Did the Supreme Court in Tasmania play any role in the abolition of the death penalty?
No, it was a political decision. Not to my knowledge. The last person to hang is described in the book. He was hung at Campbell Street at 5 o'clock in the morning. And after that, there was a political decision made to abolish... it's a bit complex. Because if someone required the judge to put the black cap on and sentence them to death, it didn't automatically follow that punishment would flow on. The judge would write a recommendation to the Attorney General, and it simply was the case that the government, through the Attorney General, on the advice of judges, stopped executing people. And it wasn't until much later that there was legislation abolishing the death penalty. So look, I'm a member of the Court of Appeal of the Kingdom of Tonga, and we still have capital punishment in Tonga, but it's not been carried out for decades. And that was the transition situation here in Tasmania until it was simply taken off the statute book. But no, I don't believe women did, or judges did, have any role in bringing it about. It was just, I think, a matter of cultural change in the community.
Can you tell me
Yep.
what the situation is with the Privy Council, both before and after Federation, and what's their relationship between the Supreme Court and the High Court?
Yes. Okay. So when our Supreme Court first started in 1824, there were appeals from the Supreme Court of Tasmania to the Privy Council, because the Privy Council was that section of the House of Lords that dealt with appeals from courts of the colonies. The House of Lords is what the United Kingdom Supreme Court is now. It's the highest domestic court. and the House of Lords and the Privy Council. Well, no, I think the Privy Council may still exist in terms of being able to take appeals from British colonies that still exist. But the Supreme Court is now the highest court in England. The appeals to the Privy Council from Australia were stopped by the Australia Acts, and I think that was not that long ago, 1990s. Someone might know better than me. 86. There you go. So yeah, that was the end of people travelling on a boat leisurely across to England, reading their brief on the way over, appearing in the Privy Council, and then sailing home fully relaxed. Well, steaming home, I should say. Yeah, but I know some lawyers who are still alive who appeared in the Privy Council and did that journey. It was sort of fascinating.
Stephen, can I just ask, at the moment, are there any issues or challenges that you perceive that are having a role with the Supreme Court of Tasmania? Any that you can comment about, in 2025, given, what is happening in society, are there particular issues that you and other judges are finding challenging?
Well, speaking for myself only, for the last 12 years, I've been very concerned about the independence of the court because little by little the government has taken over functions, certainly administrative functions, and it's been death by a thousand cuts. I don't think anybody ever intended to do it, but when the Public Service Act came in, the Public Service Commission had decided that the registrar of the court and employees of the court should be public servants and not employed by the court. And then when the State Service Act came in, once again, employees, our staff became employees, state service employees. Then when, let's say, email started, I don't know, I remember it well, but the Chief Justice of the day had no IT knowledge at all and was quite happy to let the Department of Justice set up our email. So my email is justice.estcourt@tas.gov.au. And that's not right. In theory, it allows an employee of the Department of Justice to view judges' emails, which might carry a draft judgment, which could influence the stock market, or a draft sentence, which could cause someone to flee or worse. So I've been moving against that for 12 years. I think it's fair to say that the new Attorney General and the new Secretary of the Department of Justice have been very sympathetic. We are in fact in the process of repatriating our email system, bringing it back within house. But then there's the same thing happened when databases came in and the criminal court and the civil court both established their computerised systems. Once again, the Department of Justice IT managed those systems, installed them, and then started charging us. That's fine, I don't mind paying, but started charging us for the IT services they provided. We need to bring those back in-house too. Just recently I refused to put an app on my phone that enables me to see my emails from my phone. For 12 years I was able to do that in the car, at home, anywhere. I could look at my court emails. But with 14 days notice, I was directed by the Department of Justice to add this app called Company Portal onto my phone, and I could only do it if I didn't have TikTok on my phone. Well, as it happens, that wouldn't have proved a problem. But I sought some advice from a friend who was in cyber security, and he said, look, a rogue player or somebody who was compromised could see everything that's on your phone. So none of the judges, as far as I'm aware, have added the app to their phones, and we will be bringing all of that back in-house. And the other thing is, there is a tendency now to want to bring everything under the one IT umbrella, so that corrections, the jail, the DPP, the lower court, the fines enforcement unit and so on can see each other's information and have a sort of a universal web, which they've dubbed Justice Connect. Well, now Marilyn Warren was the Chief Justice of Victoria when the Victorian government sought to do this, and she said, there is no way, we will pull the plug, this is quote, we will pull the plug and go back to typewriters before we will permit this. And then as a result of that, she negotiated with the government to separate the court altogether from the executive under a thing called the Victorian Courts Authority Act. I've been seeking to do the same in a more simplistic way, to give us the same legislation that the High Court has, where we manage our own staff, we manage our own finances, we submit our own budget requests and so on. So that's the other thing. The budget used to be very much in the hands of the Supreme Court. That's slipped over time, so we don't even get consulted about it. We're regarded by the Department of Justice as an output. Well, now, institutions are fragile. You keep letting that happen.
A slippery slope. Okay, well, we've unfortunately run out of time. Thank you so much, Justice Stephen Estcourt, for coming along and giving up your time this morning to talk to us. It's been very interesting and very illuminating. So please, thank you on behalf of U3A, and can everybody please put your hands together.
One last thing, I do a bit of medicine down here.